Both stand on the facts, you can directly go to the issues.
Thank you, Lordship. So, Lordship, in the present case, we are arguing, our team A is arguing on behalf of our clients plaintiffs, Lordship. And first three issues will be argued by myself, and the remaining three issues will be argued by my co-counsel. Thank you, Lordship. The first issue is whether the suit filed by the plaintiffs against defendants under the Patent Act and Trademark Act is maintainable. Your Lordship, it is humbly submitted that the present plaintiff is maintainable. In the instant case, the plaintiffs invented a unique separator by name GEK, for which plaintiffs has invested a lot of money and a lot of time for inventing these. And in the year 2007 itself, the plaintiffs have got patent over this, bearing number 42231 in India for the product separator and also for various countries. Your Lordship, it is humbly submitted that the defendants has infringed our plaintiff's patented product separator by name GEK. Your Lordship, the term infringement is not explained in the Act, but the literal meaning of the term infringement was the improper use of a patent writing, graphic or trademark without permission, without notice, and especially without contracting for payment of royalty. Your Lordship, in the present case, in the 2007, our clients plaintiffs got the patent. In the 2008, the defendant company has approached us for the voluntary license for this patented product. But in the 2008, we rejected it because of the not up to mark. The company has not up to mark of our company. And in the 2012, in 2013, our technical team has observed that our good was infringed by the defendant's company. Your Lordship, under Section 48 of the Patents Act 1970, the first plaintiff, being the patentee, has an exclusive right to prevent the third parties from the act of making, using, offering of sale, selling or importing the patented product in India without the patent's consent. Your Lordship, if anything against the Section 48 has happened, it amounts to infringement. In the instant case, without our permission, the defendants are making and selling the goods. So it's a clear act of an infringement under Section 48, Your Lordship. And Your Lordship,
but they also claim that they are manufacturing it right from such long time, right?
Yes, Your Lordship, they claim.
So how do you maintain your argument saying that they have copied or manufacturing the same now?
Your Lordship, we have our patent product has our own uniquity and novelty. Our patent product are selling 2 lakhs units per year, and no customer has any remarks over any piece. That's our novelty about our machine. In the 2008 itself, they came to us asking voluntary license, that they are accepting that we have our...
The facts of the case doesn't say that there has been any complaint made to you saying that the defendant had copied your product or that they are passing off their product as your product. So how do you say that there has been infringement?
Your Lordship, we have observed, our technical teams observed. So technical persons have full good knowledge over every technical aspect, and they observed it and they reported to our company, and we appointed Mr. Chintamani, an industrial investigator, and basing on his report only, we issued the cease and desist notice that you are infringing our patented goods. Basing on that, they moved to the Mumbai High Court for groundless threats. Your Lordship, in the instant case, Your Lordship, the Patent Act is silent about the limitation. But under Article 137 of Limitation Act 1963 clearly says that any other application for which no period limitation is provided elsewhere is 3 years from the date of when the right to sue accrues. In the instant case, after we knowing about the infringement had taken place, we given a notice. We are under the limitation only. And in the second thing, Your Lordship, in their submission of memorials, they reported that the cause of action does not arise in the Hyderabad. But Your Lordship, under Section 20 of the CPC has clearly says that, according to Section 20 of CPC, the plaintiff can bring the suit for infringement in a court which has jurisdiction in the area where the defendant resides or carries on a business or personally works for gain. The plaintiff can also bring the suit for infringement in a court which has jurisdiction in the area where the infringing activity could take. In the instant case, the defendant company is manufacturing the infringed goods in Hyderabad itself. So, Your Lordship, my client has filed a suit in the Hyderabad court, and they cannot say that the Hyderabad court has no jurisdiction. And Your Lordship, based on these arguments, I would like to complete the first issue and I would like to move to the second issue. Thank you, Your Lordship. Your Lordship, the second issue is whether the act of the first defendant in manufacturing and selling separators similar to the patented separators of plaintiff amounts to infringement of the patented rights of plaintiff. Your Lordship, it is proved that we got a patent. The patent officer will have, the patent, before granting the patent, the controller will have the authoritative check. And he will got the report, he will collect the reports from the technical team, and then only he will issue. And before granting the patent, he will publish in the Gazette. At that time, they didn't raise any objections. And we got the patent in 2007. And from 2007 so far, in 2014, almost 8 years passed. So far they didn't raise it, and now they are raising. For now, why they are raising is, we observed that our goods were infringed, and we claimed that you are infringing us. Then, to cover the defendant's mistake, they are claiming that the patent itself is not a valid, is invalid, it is not a patentable valid. For covering their mistake only. Your Lordship, I had already came to notice that the term infringement was not defined. The literal meaning was without permission or for payment of a royalty. They had not taken us permission. They asked us permission. We rejected it. And without our permission, they did it. And by the section 48 is giving my client a right to prevent all these kind of.
In the light of your argument, 3 years is the limitation period.
Yes,
Article 137.